Yeah. I think we will start and then. Good afternoon, ladies and gentlemen. Welcome to this panel in the broader context of the theme for this conference, which is redefining legal practice in the age of disruption. This panel today is going to discuss a very interesting theme, which is revitalizing legal education, rethinking how and what we teach in law schools and universities, but also our continuous legal education, how we do it and what we do. My name is Hope Atuhaire Kisitu. I am your moderator. I am an advocate and the Director Legal and Corporate Affairs at Uganda Development Corporation. Welcome and good to have you here. We are ready to start. We have a panel of 6. 5 are here with me, and one person is going to be joining us online. He's already online. And it is now my pleasure to introduce to you our panelists. I will start from my extreme right, and we have Dr. Benson Tusasire, a lecturer and head of Department of Public and Comparative Law, School of Law, Makerere University, and also the managing partner at Tusasire and Company Advocates. Dr. Benson, you're very welcome. Please welcome him. Next to Dr. Benson is Ms. Acheng Miriam, who is a lecturer at Uganda Christian University School of Law and also a practicing advocate with Bukenya, Chemonges, and Company Advocates. Miriam, you're welcome. Next to me, my immediate right, is Ms. Hamida Nagadia, the Acting Dean, Faculty of Law, Islamic University in Uganda. She's also the legal advisor for the Islamic University Academic Staff Association and the Director, Open Economy Agencies Limited. Please welcome Ms. Nagadia. And now, on my immediate left is Mr. George Obunyokol. I am actually debating whether I should introduce him, or you know him very well, but it's only right that I do introduce him. Mr. George Obunyokol is the chairperson of the Law Council Committee of Legal Education and Training. He's an advocate of the courts of judicature and practices with GP advocates. I think now you know why I said you should know him, because he supervises all of us. We must be compliant on our CLE. George, you're welcome. And online, joining us all the way from Nairobi, Kenya, is Senior Counsel Advocate Chacha Odera, who is a senior partner at Oraro and Company Advocates. Can you hear us? I think you're muted. Can you hear us? I need to be sure that, Mr. Chacha, I need to be sure that you can hear us. Yes, we can hear you. Thank you. And thank you for joining us. Mr. Chacha is the senior partner at Oraro and Company Advocates and practices in the Dispute Resolution Practice Group. With 34 years of experience, he has represented local and international clients in commercial disputes, constitutional law, electoral disputes, employment, insolvency, among others. And he's also a member of the adjunct faculty at Strathmore Law School in Nairobi, Kenya. Please join me to welcome Mr. Chacha. I'd like to recognize all the senior members of the bar here present. Mr. Magala, thank you for joining us. Mr. Chiboneka, thank you for joining us. Mr. Mbabazi, sorry, thank you for joining us. My apologies. But a very warm welcome to all of you. We are delighted to be discussing with you this afternoon. Legal education has long been the cornerstone of producing competent and ethical legal professionals. However, the evolving legal landscape, marked by technological advancements, shifting client expectations, and global interconnectedness, demand a critical examination of traditional legal education as we know it. So this breakout session seeks to foster a comprehensive dialogue among legal educators, as I have introduced them to you, practitioners, and stakeholders to reevaluate legal education approaches and content in light of the demands of contemporary legal practice. Yesterday, we did hear what the keynote we did hear from Dr. Muvawala, who gave the keynote address. And he said there's an oversupply of lawyers. And in his view, government should actually stop paying for legal education. And this morning, we also heard that there are 12 universities with law schools. And so against that context, we really want to discuss a number of things related to legal education in light of the bigger theme for this conference, which I have already highlighted as redefining legal practice in the age of disruption. But before I ask the panelists to specific questions, let me also recognize the presence of Dr. Pamela Tebishira Karyagira, former Dean, Faculty of Law, Uganda Christian University, and now Chairperson of Uganda Law Reform Commission. Welcome, Pamela. And I am going to start with Dr. Benson, because that's where it all starts, at the Faculty of Law. We want to discuss, or for you to highlight for us, what is the curriculum like? What has changed? And what should we, in light of the changes that we have seen in the legal profession, what should we be rethinking in terms of the curriculum and the content for legal education at university?
Yes, thank you, moderator. As you heard, I'm Mutusasirwe. I'm from law school, Makerere. I've been there forever. I was a student at law school before some of you were born, 1991 to 1994. Then LDC 95 to 96. It's so long ago. Now, recently, I was asked to make a presentation to my colleagues, my fellow lecturers at the law school. And I asked them something which I also want you to think about. When you stand in front of a law class as a lecturer, because all of you are lawyers, so you are either lecturers or you qualify to be lecturers. But if you stood in front of a law class, what would you be trying to achieve? You know, the problem with this country is that people do things far. You teach, I've taught how many years, but if you ask me or many other people what we try to achieve when we teach, you find people don't give it a thought. They teach 1 year, 2 years, 10 years, 20 years, it just teaches. What are you really trying to achieve when you teach a law class? Second question, when a parent sends a child to a law school, what does he want the school to do with that child? Or when a student joins law school, what does he want? Thirdly, government. What kind of lawyer is government looking for? Fourthly, a private an owner of a private university, like UCU, like what does the owner want? The university, what kind of lawyer does he want, he or she, or the institution, the company, whatever, want to bring out? What kind of lawyer do they want to bring out? Now, you will realize that the interests of all those four might not agree. Now, how do you design a curriculum that will address all those interests, which may not necessarily agree? And that is the problem that faces the law teacher. Definitely, we are going through changing times. That one is not debatable. Definitely, new times call for new approaches. You cannot continue doing the same, what you have been doing the same way when things have changed. That, again, is not debatable. So the changing times definitely require us to consider changing how we teach our lawyers so that we better prepare them to face what they called yesterday the brave new world. In the face of changes, you can't continue teaching Stone Age pedagogies that you were teaching before those changes. Now the question then is it necessarily true that our legal education is somehow unsuited for the changing times? Because this whole debate seems to assume that our legal education is now unsuited for the changing times. But is that really true? Or you can put it differently. Have our law schools addressed the changing times? Really? But I can even put it more differently. Can a law school manage, even if it wanted to, manage to adjust its curriculum to keep pace with changing times? Because you may find that the changes are so fast that before you even roll out a curriculum, it becomes obsolete and new changes call for a revision. And we have faced that at law school, as I later on highlight. We introduced new course content. It takes forever to approve anything in this country. Before it is approved, it has already become obsolete, and we are back to the drawing board. So can a law school change curriculum sufficiently fast enough to address changing times? My answer to that is that probably you cannot. So what is then to be done? To me, changing content may be necessary at certain points, especially when the new changes are so fundamental. But you might not be able to catch with the changes. So the better thing to do is not to keep changing content to fit the times. The better thing is to train a lawyer who is so versatile that he can fit in any changing times, or at least in most. It might not be realistic to try to change content every time there is a major change. It might be important rather to bring out a law graduate who can fit most changes. Because imagine, COVID comes in, you can no longer have direct contact classes, you change and provide for online teaching. Climate change comes in, you change. China emerges as a world power, you change to fit in the Chinese interests because your education was Western oriented. Electric cars come up, you design a curriculum that addresses the reality of electric cars. A new political regime comes up, you change to fit the interests of the new government. Oil and gas comes in, you change to put in oil and gas. How fast can you change? It may not be possible, but you can have a law student who is so versatile that any changes, he or she takes them on board seamlessly. To me, that's the way to go. We can use Mao's example of yesterday, David and Goliath. That, he told us that David, although he was not a trained general, he had grown up herding goats, and so he knew how to use stones to kill wolves, and he used that technique to defeat a giant. That was possible because David, you remember, Israel is in the Negev desert, which is a stony desert. So he had learned to use stones. But what if he had met Goliath in a forest? Would his technique of throwing stones help him to throw sticks? Possibly not. What if he met Goliath in a lake? He has grown up in a desert. Would he be able to drown Goliath in a lake when he can't even swim because he has not trained in water? No. But you could possibly have a David who is able to survive in a desert, in a forest, and in water conditions. So that's a better David, rather than a David who is good at throwing stones but cannot throw anything else. To me, that's the idea. So what I'm preaching, therefore, is we should move away from trying to keep tinkering with content to fit the times, and instead train lawyers who are versatile enough to fit any changing times. In other words, you move away from what we call the bank concept of education. The bank concept of education is where you look at a student as a depository, a kind of piggy bank. You know those piggy banks kids use, those boxes which are sealed, you can put in money but you can't get it out. Then you keep putting in money and at the end you can break the box and get out the money. Now, the teacher is the depositor. The student is the depository. You keep throwing in knowledge. Then at the end you pull out the knowledge and use it. That bank concept of education may not work because the facts you put in, by the time you try to use them, they are useless. Okay? So that can be the trouble. Now, a curriculum, you see, part of the problem which leads people to try to tinker with the content every time is a misunderstanding of what a curriculum is about. People think the curriculum is the content of what you teach. That is only 1/3 of a curriculum. Curriculum is 3 things: what you teach, content, how you teach it, what the Army calls the MOI, methodology of instruction, how you teach it. Then 3, the circumstances you create in which knowledge is delivered, which may shape a student. Now, those last 2 are more important than even the content. A student who is taught critical thinking, whose intellectual rigor is trained, who is taught the art of inquiry, the art of academic curiosity, is more suited to changing times than one who is given very good, excellent facts. Because when the facts change, the other one becomes useless. Now, I want to put that now in practical terms. How has Makerere responded to changes in terms of what I'm saying? You see, you have 3 kinds of curriculum. There's what we call a transmissive curriculum. A transmissive...
Doctor, yes. Sorry to interrupt you in 2 minutes.
2 minutes? You want everything in 2 minutes?
No. The how Makerere has done that.
Yes, a transmissive curriculum gives you skills and facts. A transactional curriculum teaches you how to practice well, become a good lawyer. A transformative curriculum teaches you change, how to manage change. And to me, that's what we have been trying to do. So we have done things at 3 levels, but to me, we have not been satisfactory in doing that. First, we have tried content change, dropping obsolete courses. Those of you who went to Makerere long ago will remember things like the law of bankruptcy. That had to change, and instead you go to insolvency, which is with both personal bankruptcy and corporate insolvency. You remember they would teach you holders in due course, and so in the law of banking. But now people don't even use checks. If checks are there, then they are no longer negotiable. So you now change and go to electronic banking. You go to type 4 microfinance banking. You go to agency banking. You go to Islamic banking. Those are now the things we emphasize, not the other ones. We have dropped most of the Marxist rhetoric and methods of criticism. In things like the law of contract, you add in electronic transactions and so on. We have added in then new subjects, introduction of new subjects, computers and the law, corporate finance law, corporate governance, health and the law, the law of the WTO, insolvency as a major subject, estate planning, social research methods. Those are meant to technically take charge of some of the changes. Are we doing it fast enough? No. Because getting a course review through the system up to National Council and the Law Council approval can take you up to 6 years. And so most of the things are already done on paper. They are not rolled out. But the ones I've mentioned are already changed. Other changes have not yet worked out. Then the other one has been structural transformation. A decision was made that since you have 12 universities which now teach law, you all don't need to do the same thing. And you know, in order to get approval of National Council, they all basically carbon copied each other's course. So they teach similar things, almost word for word. So Makerere has now moved, therefore, from emphasizing the first degree to what they are calling a research-led university, whereby it concentrates on postgraduate education, master's and PhD, and postdoctoral research, and then actual research and innovations. And that is now the emphasis. And that takes so many forms. First, at one time we were admitting around 400 undergraduate students. We have already reduced between 250 and 280 students every year to pave way for more postgraduates. When the LLM was introduced in the mid-1990s, it had 3-4 students every year. In 2020, we had moved to 30 students graduating with masters in law. 2021-22, because of COVID, it went down to around 18. We have, last year, we admitted 84. I think this year we have admitted 150 for masters only. That is where we are going. Then we have increased, we started the Doctor of Law, and it has been moving slowly. I'm one of the products, incidentally. We are, I think 4 now, so far graduated on the LLD. But what we are now doing, we should be able, next year we are graduating 1, we should be able to graduate at least 5 every year. And when you look at the multiplicity of the areas of specialization of the current crop of students who are doing the doctorate, then you see that you are really getting specialists. Then the newer universities, which may not have the capacity for that kind of research, deep research, will first concentrate on the LLB, and hopefully we give them then the trained staff to use in delivering that.
Okay,
we have introduced.
Thank you, Doctor. Let me stop you there. Okay. We will definitely continue the discussion. Okay. And it's quite an interesting discussion and very informative. I now want to go to Mr. Chacha. Mr. Chacha, can you hear me?
Yes, I can.
You have heard what Dr. Benson has submitted on curriculum content. And I would like to hear your views from the Kenya perspective, but also more specifically on technology integration and future-ready graduates. Is it important that we integrate technology education to prepare graduates for the digital age and familiarize students with legal tech tools?
Yes, thank you very much. Thank you very much. I've heard what the Don has said, and I'm in agreement with him. One of the things which has ailed legal education and education in general is the knee-jerk reaction of tending to react to emerging circumstances from time to time. You will recall lawyers were very, very reluctant to embrace technology. And that reluctance was not only at the practice stage, but also at the university, where even though one could embrace technology as a tool to enhance whether it is preparation whether it's research or whether it's preparation of a case in practice, lawyers were literally the last people, lawyers and doctors were the last people to embrace technology. So it is necessary that we must firstly integrate technology as a tool at the universities in preparation for graduate-ready graduates. People who will come out ready for practice. In Kenya, March 2020 was a turning point where there was disruption, both from the teaching stage, that is at the universities, and stage, that is the practitioners of law. You will recall, or you may recall, that that was the period that many African countries, and indeed worldwide, many countries shut down as a result of the COVID pandemic. So we were compelled to adjust to the new circumstance and embrace technology and learn as we utilized it. Indeed, one of the interesting things about both university and legal practice, there was resistance, that even in the face of the ravages of COVID, people were saying, open up the universities, open up the courts, let's go back and let's reclaim back our normal lives. The truth of the matter is that it wasn't what one would call some form of courage that they wanted the country opened up. It was the reluctance to embrace technology. Once we were then compelled to embrace technology, and I have the advantage of being both a member of the adjunct faculty of the Strathmore Law School, where I teach law, and a practitioner. One thing that I have noted is that there is what one would call a disconnect. The university have embraced technology for their purpose, and that is the purpose of teaching. We practitioners have embraced technology for purpose of plying our trade. Unfortunately, we haven't quite had a conversation where the university embraces technology to prepare graduates to practice. And one of the things which both university and practitioners have in common, as they embrace technology, they haven't designed it to facilitate business so as to accommodate all the players. And indeed, they tend to overlook certain social realities. At the time I joined practice, there were only 2 visually impaired lawyers, and one of them, as is now, sits in the Court of Appeal. Today, we have close to 20 visually impaired lawyers in Kenya. At the time when we were then putting technology into practice, one of the things which we overlooked is how do we accommodate those people who are visually impaired. The universities have tried addressing it in at least the university I teach in. They have tried by creating various programs which the visually impaired students can utilize in order to participate fully in both class and in other activities. The other problem that the COVID brought about, which technology tried addressing, and in addressing overlooked certain aspects, is the human interface. You will find, like in our day-to-day court appearances, you will find that we do have visually impaired lawyers who are addressing the court. But when you have a presiding judicial officer who does not take time to be interactive, the advocate who's visually impaired is unable to determine whether his or her point has been taken and whether he should move to the next point. And we have then now reached a stage when we are deliberately, in my own office, I do have one of my colleagues who's visually impaired. Before that, I did have another colleague who trained through us and now is doing his PhD, who was visually impaired. And it is as a result of these interactions that I have become sensitive to some of the difficulties that they face. So in court, a lawyer is submitting. The judge does not either respond or acknowledge having asked him to proceed on. So the person finds himself lost. And even when it comes to questions of service of documents, I have now come to learn that merely serving an advocate with a scanned PDF document, you will find that most visually impaired people, the programs that they use in order to read will not necessarily be able to convert that scanned PDF in which they can read. And that also applies when we are teaching at the universities. We must be sensitive that in an inclusive society, we must invest in order to carry everybody along. Basic things like even course list, the docket for various judges, what they are, which cases are allocated to them and the time which is allocated. You will be surprised that in Kenya, the format in which it is disseminated is not a format which is friendly to impaired people. And when you talk about the people who have a hearing impairment, theirs is even worse, in the sense that in this new platform that we are conducting our proceedings, we don't have sign language people to be able to accommodate them. And even at the universities, it is difficult. I'm yet to come across instances where universities are taking deliberate steps to accommodate people with hearing impairment by adding on to the resource a sign language interpreter. So there's a necessity to look at all these various things, even as we embrace technology, both at the learning level and at the time when we are practicing. So far, we've had certain steps which have been taken for inclusivity, but those are not good enough. Steps like in Kenya, we do have what you call People with a Disability Act, where they can apply for various exemptions, firstly for tax rebates and for extension of the retirement date. But the truth be told, these colleagues of ours who have visual impairment or hearing impairment, they want to be treated just like any other normal person. So they don't want tokens. They want an environment, whether at the learning level, whether at the practice level, whether we are all talking in terms of embracing technology, they all want to be carried along. And as we design the various tools to accommodate ourselves, we should also bear them in mind. Thank you very much.
Thank you very much, Mr. Churchill. I hear you very loud and clear on inclusivity, so that we can all be carried along or go along together. And I think those are very useful insights into the topic of discussion today. I will now go over to you, Miriam. And I want us to examine the theory and practice of law. Dr. Benson, when he was highlighting the curriculum, he said the curriculum is three things. What you teach, I think that's the theory, how you teach it, and circumstances in which you teach it. All those three aspects constitute the curriculum. And I want you to share with us how we can bridge the gap between theory and practice from your perspective as a law lecturer, perhaps with examples of what you're doing at UCU. Thank you.
Okay, thank you so much, moderator. Yes, concerning theory and practice, one of the aspects that we have realized is that some of the course units that are being taught at law school are actually outdated. And some of the course units that are being taught are not practical enough. Like we've heard from the previous discussants, technology has advanced, and it's important that we teach practical aspects of the law so that once students graduate from the universities, they are able to be marketable. We all know that student numbers have increased, yet the market is still small. For example, today's market, in line with technological advancement, a student should be able to appreciate ICT skills. And I will give an example of UCU, where I teach. During COVID time, UCU was the first school of law to embrace online teaching. Not only school of law, but the entire university. While people were still in the lockdown, for us the semester system proceeded. We embarked on online system of teaching. We adopted information management systems that enhanced online teaching. For example, we have a system which is called Alpha, and through Alpha system, information is processed and stored. Through Alpha, we are able to do communication from the different departments or within the different departments, both teaching staff and administrative staff. So Alpha system has helped the university to advance technologically. You will realize that even exam permits are processed through Alpha. Students no longer have to access their marks through the faculty or through the School of Law. All marks are uploaded through Alpha, and students are expected to check for their marks through Alpha. When it comes to examination, students are supposed to extract their examination permits through Alpha. This is information management system. And at the end of the day, we see that when it came to sending students to LDC, the School of Law UCU was the first to send students to LDC during COVID time, because our semester system was already done and our students were ready to graduate by the time LDC was enrolling students for that academic year. I think it was 2020, 2021. So what am I trying to say? That most of our course contents or course outline, course units are outdated. We need to embrace ICT skills. When you look at our court system, most of the things have gone digital. Talk about filing cases. In some jurisdictions, even cases are had online. So if, for example, our students are to be marketable, they have to be able to appreciate ICT skills. I have heard some of the employers complaining that most of our students cannot even, for example, do research online. They do not know the basics. They are given a computer to use, they do not know the basics. So it is important that in law schools you are able to appreciate ICT skills, and let it begin right from first year, that students are able to be taught ICT skills, artificial intelligence, and at the end of the day, our students will be able to be marketable. Some employers are unable to employ our students because they do not have the ICT skills that are required. And right now with cross-border practice, most firms want to partner with other firms abroad. How else will you be able to do cross-border practice if you do not appreciate ICT skills? Then still in line with theory and practice, I will talk about the research component. In some schools of law, research is not emphasized. Maybe because we do not have lecturers who appreciate research, or lecturers who are well-trained to do research. And at the end of the day, we find that also our students are not well-trained in research. And when the students get to the field, we find employers who have complained about students who cannot do simple research. You give them a case to handle, and when you look at the brief that they have written, you realize that these are students who only crammed the law, but they cannot go an extra mile to research, to reason. They do not have the analytical skills. And so my submission is that in law schools, it is important that we emphasize on the research component. This begins even with the lecturers. I know that in some law schools, the research component is not funded. And of course, if the lecturers do not have the funding to do research, how will they emphasize that even to their very own students? So research component should be able to be emphasized in law school, so that when students get to the field, they are able to do a lot of research, because with these emerging trends, with contemporary issues, you should be able to research. Most employers look for students Most employers are interested in students who go an extra mile, who can research and reason. The other aspect about the theory and practice is concerning some of the emerging trends. For example, talk about ADR. When you look at our law schools, right from first year, a student is taught about how to write brief facts, how to raise issues, how to resolve issues, identifying cause of action, meaning that a student is being prepared for litigation. That is the emphasis right from first year up to LDC. But the ADR component is not emphasized. If at all it is there, probably it's an elective subject in some of the law schools. In some law schools, it's not even mentioned at all in any of the course units. But you realize that with the case backlogs that we have in our court system, we can no longer sit back and say, okay, litigation is the way to go. We need to embrace ADR. And it should not even be called ADR, alternative dispute resolution, meaning that it is a secondary thing, but it should be a primary thing from day one. And so if you're going to embrace ADR, we should be able to make it a compulsory thing in law schools. Right from first year, there should be a course unit structured actually across the 4 years. Students should be taught the principles of ADR. There should be a demonstration in class on how ADR should be conducted, because, well, a student can say, in the field, this is something small I will learn. But if you do not have the ADR skills, at the end of the day, you will not be able to settle dispute. So courses like ADR should be emphasized right from first year to fourth year, so that at the end of the day, when students get into the field, they are able to do ADR. We find that we have so many students, like I mentioned before, the student numbers have increased, yet the market is still small. There are so many students that have recently graduated from LDC, and they get into the market and they have no jobs, and they're wondering, how are we
In the recent past, I think there was a parent who was called to one of the universities, and their son was really being sent away because of poor performance. And he said, you know, lecturers, you assume that these kids, those were his words, these kids are grown. You are not helping them to progress. You assume these are adults who have come to learn. Yes, they have come to learn, but they still need to be handheld through the process. So in terms of assessment and feedback to enable the student, can you give us your comments? Thank you.
Thank you so much, moderator. In terms of assessment and feedback, my opinion is, one, before even I move to assessment, we need to change the pedagogy, the methods of teaching law, because it's through the different methods of teaching law that we come up with assessments. There are basically two fundamental forms of assessment, that is summative assessment and then the formative assessment. But I'll go with the one that inclines with Keizin theory, which basically includes that there must be continuous improvement. And in continuous improvement, that is where we have to adapt different modes of assessing students in order to get the quality that we were expected to provide as an institution. So in these assessments, we to come up with the different good models of assessing students. As a lecturer, and as an administrator, I'm going to speak in two perspectives. As an administrator, we are inclined to have outcomes of every course, or course objectives and course outlines. Those that are in terms of academic and those that are in terms of other issues. Because in education, in legal education, we do not only look at the legal education only, we also look at the other factors that have an impact on the legal education. So, when you have a course, each course or every curriculum provides for different contents that are supposed to be taught to the learners. So as a lecturer, I'm supposed to have the course content. What am I supposed to cover? How best can I cover this content that I'm supposed to cover? Which methodologies am I going to use to ensure that I get the course objective done? What are the varying dilemmas or challenges that are likely to occur in this kind of course that I'm teaching? Teaching students differ depending on the nature of students that you may be having and the different circumstances that may be availing at different times. In short of that, what I mean is that the moment you come in a class for the first time as a lecturer, you, by virtue of observation and the demeanor of students, you will understand these are, as time goes on, you understand that the kind of students that you have, whether they are participative students, active students, dormant students. So you need to come up with models that are going to make you get the outcome that you want. And that inclines that you're supposed to give or use different models of teaching, because different models of teaching will bring you different participation levels of students. For example, we normally use, as IU, we normally use the moot court kind of teaching, where you divide a class into different groups, where we can have the plaintiff side and then the defendant side. And then in using the moot court mode of teaching, the incense is to bring all students on board despite their numbers. Also, you can use the mode of research, where you tell students to go and you ask, maybe you give them a high order question where they are going to go and research and find a problem and find answers to what exactly you want as a teacher. So depending on the class, depending on the size of the class, the nature of the students, the circumstances that they are in, because definitely a student who is being taught at Kampala is different from a student who is being taught in Mbarara, is different from a student that is being taught in Mbali. Because even the environments themselves are different. You can see that a student in Kampala may be having challenges because of the collocation itself. You find that a student in Mbale, let me use an example. We have Kampala campus and we have Mbale campus. Those students are totally different, even in terms of performance, in terms of concentration. So the energy that a person is going to use to get the outcome of a student in Mbale are totally different from the methodology someone is going to use in Kampala campus. So for me, I will go with, I will have my view that the methods of assessment depends on the models of teaching a person has, the nature of the class, the nature of the students, the surrounding environment, the facilities that are available. Because all those ones.
Hamid, let me ask you. You raised something interesting there, and let me now ask you a direct question.
Yes.
But I'll give context to it. When I did my postgraduate out of this country, the class, like 3/4 were Chinese. They don't understand English, so they have translators in class, and so we asked the lecturers, how do you assess the Chinese? Because in the exam they don't have the translators, but they must write the exam in English, and yet they don't really understand. Because you're saying it depends on the context. You know, the person in Kampala is different from the one in Mbale and things like that. And the lecturer said, by the way, we are not really marking English per se, but in their broken English, the idea is there. So if the idea is there, they will be rewarded for it. As long as I can read and make out, you know, I see that there's an idea being developed which is correct, I will reward them for it. Which, for me, I can write very clearly in English and express it. For them, they cannot. And he said, and besides, when they leave here and go back to China, they are not going to be speaking English. They are going back to their Chinese language. Are those some of the things you're doing here in terms of law school? Are you recognizing that maybe some of these things need to be taken into consideration? The student has an idea, may not have developed, but it is there. Would you reward them for that in terms of the assessment, when you're doing an assessment of their performance?
In my own perception as a person is that, yes, you can reward them for the efforts, because looking at the global perspective, we are not only teaching nationals of Uganda, we are teaching even international students. That also takes me back to the curriculum designing, the designing of the curriculum, where in certain exceptional circumstances, you may be inclined to teach people that may not even have ideas of what you're actually talking about in terms of the language that you're using. But how is the curriculum designed itself? The way the curriculum is designed also brings up different models of teaching. For example, if you're teaching students, assuming you're teaching students, you're not only supposed to incline to the national realities that are happening, but you're also inclined to use the international realities that are happening, so that a student can be able to intrigue and be flexible to fit in any environment, because the legal practice or legal education is meant to achieve certain objectives. And those objectives are not only to end in the law school, but they are also meant to be continuous even in their legal practice, or even if they choose to any other kind of career. There are certain skills that I believe every education program that is meant to achieve. It is not only meant to achieve that you're only supposed to understand that content, but have you intrigued that student the critical analysis skill, that even if you have not taught them that specific aspect, but they have the skill to understand it, because they know how to do research. They have the skill to do research and understand all those other aspects that they are being told to research about. So in assessments, going back to the question, is that in the assessments, the different models of assessments, also teachers and learners need to be indicted on the different models of assessments and the objectives to be ascertained in those different models of assessment. One school of thought may believe that I'm going to do formative assessments, where I'm going to be giving high-order questions that require critical thinking, or even give examinations. Another one may think I'm going to be giving problem questions, where I give a scenario that is in form of a problem for the learners to give me feedback on what they understand by that. Another one may choose to be giving them field study questions, where people go to the field, understand different problems, and then come up with a solution. There's also another one that I've been observing quite for some time, is coming up with articles. You tell students, maybe give them a theme of what the problem you want them to investigate about, then you tell them to go to the field, come up with even research papers. And this has, in my observation, is that it actually instills skills of thinking to the learners. It improves them as persons in their career development. And again, it also enables one to be in capacity to achieve the objectives of learning. So not only should we look at the end of semester examinations, but we should look at the continuous improvement of students, because it is the continuous improvement which is in terms of the methodologies that a person uses to actually equip them with skills. Because as we can all observe as teachers, as lecturers, is that in a class, there are different kinds of students. There are those students that will understand immediately that you tell them something. There are those that will understand after 2 days. There are also those students that will understand in the due course. But you, as the tutor or as a lecturer, what methods are you using to ensure that all those students are learning? So we should have a student-centered learning. And with a new global environment and changes that are coming up, we can no longer use only the lecture method. For me, I propose, as a nation, we should be student-centered, and we should have a competency-based kind of curriculum, like the ones that has commenced with the lower levels of learning, so that we are in capacity to align ourselves with the kind of learners that we are yet to receive at higher institutions of learning. For me, and then the other aspect that I would like to propose is...
you have just 1 minute, sorry.
Okay.
Yes.
The other aspect that I would like to propose is that, based on the challenges that are facing the legal education in Uganda, and one of my observations is that of the curriculum. I'm suggesting, in my own view, that let all of us have, maybe have one committee that may be guided with National Council of Higher Education and Law Council. We come up with one curriculum for all the law schools in Uganda. That is going to save on the costs in terms of resources and even in terms of reviewing those curriculums, so that all of us are moving on the same page at the same time. And in case of any changes, it is done at the national level, to avoid wasting time, and also to avoid the burden on the law schools, and also the burden on the National Council of Higher Education. Because I may not know what the National Council really goes through to look at all those curriculums. But again, we are in the centralized system. The world is integrating. We need to engage ourselves in the new models that are coming up, and we need also to be cost effective in terms of time, in terms of management, and in terms of educational quality. I submit. Thank you for listening.
Thank you very much, Hamida. And I like that you have touched on there's been a curriculum change with the secondary schools, starting with the O level, and they will be coming to you. So I hope that at university you'll be prepared for those students. But you have lightly touched on it. Now let me come to you, George. As the supervisor for continuous legal education, I seem to hear Benson make a case for you. He cannot deal with everything at law school, and therefore the 20 CLE points, or maybe now 40, I hope you're not thinking of increasing them to 40 from what he has submitted. But I think what COVID showed us was a different way of doing CLEs, we all of a sudden we had so many webinars on even basic things like how to stay well, how to have your mental health, mentally stable, to be mentally stable during this period. So webinars and other modes of attaining your CLEs have come up. But what are you doing to ensure that these are received, they are appreciated, they are relevant to the legal profession, and that ultimately CLE remains something that we must be entrenched with?
Thank you very much. My name is Jojo Mnyoko. I'm here in my capacity as the chairperson of the Committee on Legal Education and Training of the Law Council. So I'm going to speak largely as a regulator, but of course the teacher in me will be creeping in, and the practitioner in me might sometimes take over. But I plead that you bear with me, because most of what I'm going to talk about will be largely from the point of view of the regulator. In fact, when I came here, I thought I was going to be asked questions on legal education and supervision. So I came largely prepared on the supervision component, but this would have been a case where I would have sought an adjournment and talk about CLE. But trying the best that I can, as you know, when you go to court, you prepare your case, but the judge may ask you something fairly obscure, but your job is to say something. So, colleagues, as you may be aware, the Advocates Amendment Act 2002 establishes the Committee on Legal Education and Training in Uganda. That committee has got several functions. The core function, I would say, is on supervision and control of professional legal education, and also it conducts continuing legal education, CLE, which is the cornerstone of this question. Now, the question is, how does Law Council, through the Committee on Legal Education, ensure that the new modes of delivery of this kind of education are relevant and useful in the changing times? How well should they be received and appreciated? It would appear as if the moderator was a fly in the wall inside our last meeting. This is one of the core areas that we, as a Committee on Legal Education, are seriously reviewing. We are very much aware the challenges that lawyers face in the present economic environment. As you may know, there is no way through which the Committee on Legal Education is able to police and supervise every lawyer to ensure that he or she is participating online the moment he or she registers through his or her mobile phone. The understanding is that once you've paid your money and you have chosen the cause or the subject, the topic for training, that you participate. But speaking as a practitioner, I have seen sometimes in court lawyers presenting their cases while at the same time having their mobile phones registered for online training. I know that human beings multitask, but I would like to know from you, colleagues, how can you effectively multitask when you are presenting your case in court? At the same time, your mobile phone is on, you are attending continuing legal education via your mobile phone while you're the one presenting. Obviously, one part must suffer. So we know that it is a serious challenge. We are trying to come up with guidelines to ensure that the mode of presentation of this information is very interactive. We're trying to make sure that where possible,
Meet Stephen. He's a certified.
if possible, and if the technology allows, there should be opportunity for retention of these materials such that the advocate may be able to follow through even after the presentation of the material. But we recognize that this is an ongoing and emerging challenge. But as you know, a lawyer must first and foremost be disciplined. You must have the self-discipline of ensuring that that which you have registered for, you take the best out of it. On the part of the Committee on Legal Education and Training, our interest is to ensure that there are minimum requirements for those who present these core areas. Are those points or areas for interaction with the fellow lawyers relevant to what is going on in the present day situations in our country? Are they relevant within the region? Are those points relevant at global level? Because we are all part of the global economy. There's also something that we have noticed. As you may see, it does not mean that every program that is available for education should be registered for by every individual. Slowly, we have no choice but to begin trying to identify areas where you may feel comfortable in. The understanding is that that which you like, you will participate in. That's the way we see it. If you like a particular area of practice and an opportunity has come for it, you spend your money to participate in it. The self-discipline in you will dictate that you will participate through and through and probably also give feedback. So we are designing mechanisms of getting feedback from participants with which we shall share together with the presenters as a way forward. I think I'll stop there for now.
Thank you, George. And those are very useful insights. And I think you still have a lot of work to do as the Committee on CLE. Members, I would like to give you an opportunity to ask questions to our panelists on anything related to what we are discussing today. And we have the microphones. If you put up your hand, we'll get a microphone to you. And as we wait, yes.
Okay, it's come on now. Thank you very much, the panelists. Some of them know that this is an area of deep interest to me that I have researched on and written on. One of the suggestions I made in a publication I wrote was perhaps it is time to rethink how we are training our lawyers. This business of having a split, have law school, LLB, then go to LDC for practical legal training. I think increasingly it's becoming obvious that perhaps we need to do this in one place. Isn't it time to combine, the theory with the practice in one place of training? Because you heard what Dr. Benson was saying, and I agree with him thoroughly. You cannot teach everything. A new flavor will keep coming up. And so we can't, the other day, I think it was a few weeks ago when we were at LDC's curriculum validation workshop. And you see the lecturers there struggling and saying, oh, by the way, now we need to include cryptocurrencies. Now we need to include capital markets. Now we should do, how much will you teach and what won't you teach? In fact, one of the suggestions that came up in the plenary, which I didn't have a chance to react to, was basic computer. LDC wanted to teach basic computer. Why? Why should you do it? If people have not learned by the time that LDC and National Council for Higher Education, by the way, which I also worked at for 6 years, says computer should be a basic at the university. Why should LDC struggle with that? But maybe, perhaps to save us, we combine this thing. Teach the low degree and then go into having just bar exams conducted by LDC as, what did you call it? Law Council, sorry. Either Law Council or LDC becomes a testing center. So people train for the 4 years or for 5 years, whatever you want it to be, and you're teaching them both things. And perhaps emphasizing more of the skills, because certain skills we can never run away from. Things like critical thinking. I remember we had that also from the presenter this morning, saying where you have the chat GPTs coming in and that sort of thing. However much you develop an AI tool, that critical thinking is necessary for every lawyer. So how about the focus being, if you come to law school and I teach you critical thinking, how to speak. One of the areas I'm interested in is rhetoric. I discovered there were professors on rhetoric. I thought, oh, this is very interesting. Just how to speak. How do you make speeches? Because lawyers are about, going and presenting your case. How do you negotiate? Those are the skills that will carry them through no matter the content. That would be a suggestion. And especially since we have law counsel here, maybe we need to think again. Should we have a split education anymore? Is it relevant?
Okay, I think George wants to make a comment on that.
Yes, thank you very much.
She has tickled you properly.
Professor has said something which is pertinent. Colleagues, I have to tell you this. Government is currently in the process of doing the preliminary work towards the amendment of the Advocates Act. And as you know, the powers of law counsel in supervising legal education in this country are derived from the Advocates Act. I would like to believe that at an appropriate time, government will see the wisdom of seeking the views of all the stakeholders, including members of the law society and the wider fraternity involved in teaching legal education. I see the points raised by Dr. Pamela, and it is one of the areas that is something worth really looking into. Does our LDC as it stands now, does it have the capacity to train postgraduate bar course students in order for us to achieve what we thought we had in mind? Many of us, when we were at LDC, were probably around only 50 several years ago. Mohammed, you remember when you were a student at LDC, probably you were about 50. Now, I understand there are probably close to 1,000 or beyond that. How? 1,500. So trying the best that they can, those great men and women who are involved in teaching should be having enough homework in their hands. And no wonder people are lamenting. People are lamenting at various quarters. People are throwing up their hands in the air as to what is happening in with the lawyers that are coming out today, but without necessarily looking at how we are managing that activity. Colleagues, we must look at this from the background of the liberalization of education in our country. That is the job that government took some time back. Currently, we have more than 10 universities, and more are still coming in. As law counsel, we have that duty and responsibility of scrutinizing the combat readiness of these universities in teaching law education in our country. My question and my point that I would like to think aloud in your presence: where should the safety valve start from? Should it be focused on the setting up of the national bar course exam? When you look at the curriculum of a typical university in Uganda, the admission requirements include, for purposes of joining university, there are probably 1 or 2 or 3. Direct entry, where you must score at least 5 passes at O level, together with the 2 passes in A level at one sitting, with just barely 1 core subject, English. Just to stretch that point, it means if you can get a subject, if you pass ATESO, I come from TESO, and I always think first in ATESO, then I combine and I translate it in English, then like that. So if I can pass my ATESO, and then pass my Swahili, and then pass English, under the current entry requirements, no one should stop me from joining the university. Critical thinking, analysis, legal reasoning, that's up to you. But under the present environment, you can admit me to study law if I can get good grades in ATESO, which I can speak even in my sleep, as long as I've scored somehow in English. The other ones, of course, is mature entry, and you all know the stories about mature age exams. As long as you are 25 years and above, and you pass the mature age entry exams above 50, that is for an average university in this country. And I think the other one is a diploma, and I remember there's another one of higher education something. Yes. So the safety valve right now appears to start from there for law exams, for a law degree that you have for O level, you pass English. Now, we need to think about this. We need really to think about this. Where should the safety valve start from? I sometimes liken the system for, teaching law education in our country is like what my science teacher in primary school taught us in the digestive system. I recall very well, he used to tell us there are 4 stages for digestion. You ingest, you break down, you absorb, and eliminate. That is what my primary school teacher taught me so many years ago. So what is being ingested and at what level? It appears that our system right now is doing it at the level that I've just talked about. But we have to accept not every person who joins the law school can conceivably end up practicing the law profession anywhere, whether in the courts, in the bank, in the classroom, anywhere. But for the Ugandans, you know what this means. This is a very dicey issue. One of the safety valves, politics interfered, and it was gotten rid of. You all know what it is. So we are thinking, should we consider having it back against all our children were being treated like orphans in neighboring countries because they had nowhere to go to. You know how they were can you imagine your child being chased away in a neighboring country because he's trying to do a bar course somewhere? So the politicians came in, but again, the side effect of it, you all know. So we have to adopt a middle ground.
George, I'm sorry, I have to cut you short. I'm advised our time is spent, and there's another panel coming in here. I do apologize that we could not finish all your points that you're trying to raise. But I would like each of you to use just 30 seconds for parting shots. What do you want to leave us with? And for Benson, I'm going to focus you on postgraduate education. Would Makere admit me if I did not have my first degree as law for a master's in law? Do we need change in that area?
No, they wouldn't admit you, and I think it should remain like that.
Thank you.
Because there are other options like the Master of Arts, the Master of Philosophy. If you want to be a Master in Law, you should have a background in law, and you are now mastering it. Because that's what it is.
Okay, we'll continue the discussion after here. I have different views on that. Mr. Chacha, I would like to give you an opportunity to give your parting shots now in about 30 seconds.
Thank you very much. Yes, really, at the end of all this, there is an urgent need that we need to relook at our training so as to be relevant in our practice. And as we are training, we should always look in terms of inclusivity. We are no longer the traditional society who only tailored what we were doing for those who we believed did not have any form of impairment. They are now amongst us, and we have to embrace them, and we have to accommodate them as we train in preparation of releasing them into legal practice. Thank you.
Thank you. Miriam, your parting shots quickly.
Okay, thank you so much. It's important that our course units are revised in the different universities so that they are able to satisfy the needs of the market, including professional values, professional ethics should be emphasized in law school so that once a student gets out, he is not only practicing law, but practicing law with ethical values in mind. Thank you.
Thank you. Hamida, Acting Dean, IU.
Thank you so much. For me, I'll leave this. The need to revamp legal education in Uganda in terms of the pedagogies that we use. The curriculum is inevitable due to the emerging trends that are happening in the world, and with Uganda specifically, with the commencement of the competence-based curriculum in lower levels, leaves us with no choice but to change our curriculum from non-competency-based to competency-based.
Thank you. George, let's have your parting shots.
I would like to call upon you to critically examine the Advocates Act together with any amendments arising from the Act that are in place, and see how we can, through our society, come up with proposals for amendment of the Act such that the same may be appropriately taken through all the stages up to Parliament, because that is where the battle line will be drawn from. If we make sure that the right safety vaults are put in place through appropriate legislation, we, for the time being, will try to see what we can do for the benefit of our country. Thank you very much.
Thank you. Our online attendance team, we have seen some comments and questions. We apologize that we've not been able to answer your questions here, but this is not the end of this discussion. I am sure we could always continue this discussion outside here or in other fora. But once again, I thank you, the participants and members who have joined us. I thank my panelists, and I think we have another session coming in. Godwin, do we have a group photograph for the panelists outside? Okay, let's meet outside as panelists for the group photo, and I wish you a good afternoon. Thank you.